Good morning, ladies and gentlemen. I really appreciate that so many of you are here right now. If I were you, I would not be that sure if I was here. But anyhow, the title of my talk is The Challenge of Balancing Digital Copyright. And since you have just learned that I'm a member of this research group, you might assume that what follows is the try to summarize what has been said and kind of introduce the upcoming panel and the suggestions that will be made. But this is not what I have in mind. What I would like to do is add a little bit of complexity to the simple picture we have before us after the discussions on Wednesday and Thursday. And the complexity I would like to add are 5 layers of content protection on the internet. So I will not only speak about copyright, but I would like to speak about 4 additional layers of content protection online. And I think that balancing these additional layers of protection is actually a challenge, which is a big challenge, and we have not said, at least in that conference, very much on those additional layers of protection. So what do I mean with these additional layers of protection? Balancing copyright and IP, what that is supposed to mean is quite clear. I think that was the topic of this conference. We balance exclusive rights on the one hand and freedoms to access and use information on the other hand. However, this approach presupposes a whole number of things. Inter alia, that the content that we are talking about can be accessed and used as a matter of fact, and not only accessed, but only permanently reproduced so that you may produce an adaptation or play with the content in the way you would like to play with it. In other words, the balancing of copyright and IP presupposes that there are no other ways to regulate the access and use of information beyond copyright. So it presupposes that copyright is everything we have to talk about in order to understand what's going on. My point is that this is an increasingly incomplete, if not incorrect, presupposition. So my point is balancing copyright IP does not suffice. That's not enough. We have to add more to the picture. And these are the 5 layers in total. I will speak about layers 2 to 5. The one is copyright. The second one is database protection, was addressed a little bit over yesterday, which I would like to call a kind of para-copyright number 1. Then comes layer 3, which is technology, access and copy controls, technological protection measures, digital rights management. Then comes another legal layer, which is anti-circumvention laws, laws that protect the integrity of technological protection measures. I would like to call that a kind of para-copyright number 2. And on top of all that is the contract, which is the master ruling them all. What I present here is clearly nothing new. It's very old. In the US, at the end of the last millennium, there were a number of papers, and in particular the book that most of you will know, Lawrence Lessig's Code and Other Laws of Cyberspace, which made the point, look, a code is law on the internet. It's the algorithm, and that was also introduced to Europe by Hugenholz and others, who wrote in 1999 already Code as Code, or the end of intellectual property as we know it. Look, I mean, that is some 17 years ago. And I would also like to refer to Stefan Bechtold, who wrote a brilliant dissertation Vom Urheber zum Informationsrecht in 2001, where he also explained that, well, there is more of regulation around than copyright. Database protection is lacking here mostly because in the US they don't have a database, right? So they don't address this issue, and perhaps that is at least a little bit of addition I can add here. Also, I have to be fashionable, and I will also use the example of text and data mining that was addressed here several times, and that is a relatively new topic. Now the question you could ask, why is Peukert getting back to this old issue? Hasn't that been explained so many times? I would say yes, correct, but perhaps it is necessary to repeat these issues and to repeat that there are more layers of protection than copyright, because I think these early writings have not triggered an intense, detailed legal debate on what the limitations of these additional layers of protection are. How could you balance, for example, technology that protects content? So how does this balancing exercise work on those additional layers of protection? And you could also wonder, well, why has this discussion not occurred? And I would argue, well, because there is still much analog world around us. And in the analog world, you only need copyright to find out what is at stake here, because paper books are available. They are not part of a protected database in the first place. You have the content before you individually. You acquire ownership via a sales contract, and then you can do with this book whatever you like. You can copy and play with the content. There are no technological protection measures, and there are also no contracts, at least no binding contracts, that limit your capacity to play with that contract. With that book. Okay, and in the analog world, we have a whole bunch of limitations which you cannot read, and that's the idea of that slide. It just tells you there's a whole list, a major list. This is from an EU directive, a whole list of limitations that tell you what you can do with this book, and this we have addressed in the course of this conference. These are limitations and exceptions that allow certain usages. Also, there are limits to the database right that I have already introduced here, because it also applies to the analog world. There are some limitations to the database right, including scientific research. However, already here you stumble across a weird thing which tells you there's something wrong with that database right, and now comes text and data mining a la Peukert. There is this weird thing of a lawful user in this limitation. You read this limitation of the database right, and you stumble across the notion only lawful users may extract data in order to pursue scientific research. We will get back to this lawful user. Okay, but we could move forward to the digital world, but still the digital offline world. And here the balancing mostly still occurs within the copyright field alone, because consumers acquire ownership in digital data carriers like CDs or DVDs. There may be shrink wrap licenses, but those are mostly not binding, so they don't really, there is no contract that enforces para-copyright limitations to what you can actually do. And also in the digital offline world, technological protection measures have not really worked very well. They had been applied to CDs, and still they seem to be applied to DVDs, but largely it's not very effective. So also in the digital offline world, I would argue technology is not really the major thing here, although if it is applied, it has legal consequences. So if there are copy controls attached to a DVD, for example, 2/3 of all limitations go away. Why? Because you must not circumvent the technological protection measure, even if you do this in order to rely on a limitation of copyright that actually allows you to copy and play with the content according to the law. But if technological protection measures are applied, all those limitations that are stricken out, are superseded by technology. And even those who are not stricken out may only be used if the right holder helps you ex post to get finally lawful access to the content. And this ex post help of the right holder is completely dysfunctional and has never been actually used. So we already see in the digital offline world that private ordering takes over. And that becomes much more prevalent in the online world, where we finally now have arrived. Okay, in the online world, we have to draw a number of distinctions. Clearly, there is a lot of freely and lawfully accessible content on the internet that you may use, for example, because there is a Creative Commons license attached to it, or there is no license attached to it whatsoever. This is the case with, for example, for all my works, which I simply put up on the internet without Creative Commons licenses, and I do it by purpose. If you're interested why I do this, I can explain afterwards. So it's accessible. You can actually play with it, and I understand that text and data mining occurs in this area, and it seems to be working fine. So, for example, I read that PubMed Central, this large medical-oriented open access database, is used for text and data mining, and that seems more or less to work. However, it's only a tiny fraction of all relevant papers. Only about 10% of all papers are available online without access restrictions and also lawfully. Then clearly, we have this illegally available content, also the databases of scientific articles which are available illegally. So you can use this data set, but it must not be used, clearly. Under EU law, the Court of Justice of the European Union has held that the digital private copy exception does not cover copies made from an unlawful source. So you must not reproduce content which comes from an unlawful source. You must not reproduce it, you must not play in other ways with it. And the big question, I believe, is whether this requirement, don't use unlawful sources, applies to all other limitations that I had on the slide also. So I think that's an open question, whether the precondition of a lawful source already kills all limitations, not only the private copy exception, but also, for example, the parody exception. You must not create a parody if you have used an unlawful source for it. And then finally, we get to what I'm mostly interested in, the content which is available online. It is lawfully available online, but you first have to pass a paywall. It's an access-controlled database, for example, an access-controlled database of a scientific publisher. Now, under which conditions may you use this database of a scientific publisher? Is it copyright law, which is actually decisive here? My answer is no. Instead, it is firstly the database right, because all scientific publishers are holders of an exclusive right in the database as such. It's an exclusive right of the maker of a database. This is now copied from this directive, it's terrible language, which shows that there has been qualitatively and or quantitatively a substantial investment. So the publisher has made a substantial investment into the database, yes, in either the obtaining, well, they don't pay for the content, but the verification or presentation, sure, there is major investment in this, of the contents to prevent extraction and or reutilization of the whole or of a substantial part of the contents of the database. So the right holder has an exclusive right to prevent researchers from extracting substantial parts to do text and data mining. The point is, this has nothing to do whatsoever with copyright. Because paragraph 4 of this article says, the right provided for in paragraph 1 shall apply irrespective of the eligibility of that database for protection by copyright or by other rights. So the database is protected by a right which has nothing to do with copyright, right? Because it's about investment, it's about money, not about creativity or something like that. Moreover, it shall apply irrespective of eligibility of the contents of that database for protection by copyright or by other rights. So, what's in that database can be raw data, right? Raw data that you might be interested in for scientific research. It need not be a copyrighted work which is in the database. It doesn't matter what's in that database. Because that right applies to any investment in a database, and the database right gives you a kind of right that is around this database and prevents others from making use of that collection, irrespective of what's in there. Beyond level 3, so that was level 2, now comes level 3, which are access controls applied to these databases. And I understand that these access controls are all over the place, and I understand that they are effective, that they are actually working. It may be possible to circumvent them, but I understand at least German scientists, even if they are capable of doing it, they are not very inclined to do it. And even if you are able to do it, then it will not help you for a very long time, because the database, the publishers will notice that there is something going on their database, someone sending a robot who downloads a massive amount of content, and that will be blocked, as we have heard yesterday from this very interesting presentation of our Italian colleague. So access controls are very effective, and circumvention doesn't actually take place. Moreover, this is the slide which should be most impressive. All limitations go away in the online world, right? These are all limitations which are available under EU law. This is everything we have, and everything goes away if there is an access control applied. Because it is in every case prohibited to circumvent these access controls, even if you want to create a parody, or if you only want to quote, let's say, a piece of a movie which is in the Netflix database, or if you want to do scientific research by using a database of a scientific publishers. So the balancing, forget about it. It is over. Moreover, we have level 5, which is the end-user license contract, which essentially defines what you can do. It mirrors the technology that is applied. So this is the legalization, you could say, of the technology which is in place. And I could read a recital of EU directive. The exceptions and limitations referred to here, the exceptions and limitations should not, however, prevent the definition of contractual relations designed to ensure fair compensation. So contract trumps any balancing. What is the consequence then for our text and data mining limitation? Under UK law, the UK went ahead and introduced in text and data mining a provision to allow for text and data for mining. And here it's already in bold what is decisive: lawful access returns. Well, it's clear why it returns, because it's a requirement under the database directive, and the EU Commission also apparently doesn't want to do away with lawful access. That will stay even if the EU introduces a mandatory text and data mining limitation. The UK repeats it, so if you have forgotten when starting to read this provision that you have to, that it requires lawful access, you read on and think, oh great, but you stumble again across lawful access. So you must not forget that you have to be a subscriber of a database. You have to pay first in order to be eligible for mining. That's the whole idea. And what are the practical consequences of that? I think we have had a very nice presentation yesterday by Christian Handke, who explained how researchers do this. And I understand that you have to go then into every database individually and check what you can mine there. And my understanding is that this is a problem in and of itself, because it could be that only the combination of all databases produces the result that you are looking for, produces the needle in the haystack that you are looking for. I believe that lawful access is a structural problem here, leaving aside the fact that you may not be able to afford this, and I'm speaking about universities clearly and not about the individual user. Then to finish, what are the limits of all these additional layers? And since there is no such thing as a free lunch, you have to take some advertisement here. Clearly I have written on this topic. I've written a German book on that, and there is now an article which summarizes the key finding of a book that is called Die Gemeinfreiheit, where I address some of these limits, unfortunately not the database thing that I also neglected for way too long. So what are the limits of the protection at layers 2 to 5, which is database, technology, anti-circumvention laws, and contract law? What are the limitations on level 2? So should we not limit the database protection? What's the problem with the database protection? The problem is lawful access. You have to be a lawful user. Now, I can't imagine how you can fix this creature as long as it contains the requirement of lawful access, because that means you have to pay in order to get access to the database, and only then are you allowed to extract data, be it on the basis of the contract or on the basis of a limitation. Doesn't matter, you have to pay. So you could strike out lawful access of that directive. But if you do this, this would imply, I believe, a right to access the database in order to read and mine, at least. And I believe this is what publishers and other database investors would not like to see. They would argue, well, then you can repeal the directive as it stands, and this would be my suggestion: repeal the directive completely and go the direction of many other countries who do not have such a para-copyright database right. For example, the US doesn't have it. Okay, so this is all perhaps a little provocative. Limitation on level 3. What's the question here? How can you limit the application of technology? Is this the question? No. The legal question would be, is it legal to lock scholarly content behind paywalls? May the application of technological protection measures be illegal? Yeah? The question is, should we prohibit the application of technology? This is a difficult question. And I would say, well, as the law stands, it is legal to apply these technological measures. I understand that someone yesterday spoke of the celestial jukebox. I missed one or two presentations. And I think that's the key term. The celestial jukebox is a topos used by Paul Goldstein in the early 1990s. And the idea is the internet is a celestial jukebox. You can access every content at any time, from any place, but you have to pay for any use you do, right? So it's pay-per-use completely, and that tells you, well, that's all technology controlled. There's no open access directly, and this celestial jukebox underlies all digital copyright, I would argue. And also, I see no other laws that prohibit the use of technology. There is a weird decision of the CJEU in the case Nintendo, where the court applies a kind of proportionality principle to to technological protection measures, but I think this decision is not correct, and it is, well, we could debate it, but I would say, as the law stands, I see no limitations to the application of technology whatsoever, but there should be a debate about which technology is lawful, whether we should regulate algorithms. I mean, there's a big debate in the US on the regulation of algorithms, and I think this is also needed here in Europe. But for the rest, I would say it is difficult to regulate on the level of the technology, so what kind of software may be applied to block access. But as a lawyer, I would ask, so what case do you have? Why would you want to circumvent a technology? Why would you prohibit a technology? Well, because the access interest is so strong, and that's a particular interest, and I would argue you can't apply this on level 3, the very abstract level of technology. You apply it on level 4 and 5, which is anti-circumvention laws and contracts. So what are the limitations on level 4, which is anti-circumvention laws? As I said, currently under EU law, anti-circumvention laws have no limit, right? They trump all limitations. And there is no limitation to this prohibition to circumvent technological protection measures. You must not circumvent that, even if it a core communicative freedom you are pursuing. Even if you circumvent the Netflix access control in order to do a parody on a movie for a very political purpose, which is clearly protected under communicative freedoms, you must not do this. I would argue, well, Cyril, if there is no help, I'm afraid I have to join the Christoph camp and look for external limitations to this very broad law, which, as I'm a German, is the Constitution. But I would not argue for a free-floating balancing exercise, but my argument is this law is, at least in some circumstances, unconstitutional. This law is unconstitutional if it prohibits the circumvention of technological measures, if it prohibits the enjoyment of core communicative freedoms. Core communicative freedoms have to trump anti-circumvention laws. So if I want to quote or make a parody of a work, these anti-circumvention laws must not prevent me from doing so. Their enforcement in those cases is unconstitutional, an unconstitutional encroachment upon one's freedoms. Well, you could debate whether text and data mining is of such an importance that it also trumps anti-circumvention laws. There is this the decision of the Amsterdam court, a recent decision that stresses the significance of text and data mining from the perspective of scientific freedom. But be careful, that decision applies to level 1 protection, to copyright protection, and not to level 4 protection, which are anti-circumvention laws. So it's a bit different issue. And to close, what about the limitations on level 5? What about limitations to contracts that govern the use of databases? The question here is, are contracts always enforceable even if they prohibit uses that are core communicative freedoms again? Yeah? Think about an end-user license that prohibits to create a permanent copy of the content without any restrictions, which means that it also prohibits you from creating a permanent copy in order to quote or to parody a work or to do some scientific research with it. The question is, are those contracts enforceable? Okay. The UK provision on text and data mining clears the matter. It says, to the extent that a term of a contract purports to prevent or restrict restrict the text and data mining limitation, that term is unenforceable, right? So law trumps contract. The balancing trumps the contract. This is a clear provision, but only with regard to that particular use. There is no EU law on copyright end-user license contracts. It's all national law, and it has not been debated in such a big, in a complete way whether contracts are enforceable. There's a very good German habilitation by Malte Stieper who addresses the issue, and he has a provision at the end of his book where he suggests a particular provision to the German Civil Code which would clearly identify that standard business terms in end-user license contracts are invalid if they run afoul of core communicative freedoms. This is essentially what I'm reporting here. And he again has to take help with external limitations, with non-copyright law, but with a general contract law. It's not already the constitution, but it's contract law. Under German law, it would be the case that a legal transaction which is contrary to public policy is void, right? And you could argue if a contract rules out core communicative freedoms, this contract is unenforceable. And with that, I'm at the end of my presentation, and I thank you for your attention.